This is PC Mark Nights of Derbyshire Constabulary. On the 21st of November 2019, he was attending a non-emergency incident in Ambergate in Derby. The police's presence had already halted traffic and Knights found it difficult to get through. So he asked the driver of the vehicle ahead to pull to one side. The driver said he was unable to and suggested that if the officer waited, he'd be able to move forward with everyone else. Knights then began taking pictures of the driver's vehicle. So the driver got out and took pictures of PC Knights, this being one of them. The driver then got back into his vehicle. As he pulled away, PC Knights leant toward the window and shouted out, "Fat cunt," at the driver. The driver stopped his vehicle and got out. He approached PC Knights and asked him to repeat what he just said. PC Knights responded by headbutting the driver in the face. It is alleged that he headbutted him so hard that the driver's teeth cut a gash into the officer's forehead that bled profusely. The driver was then thrown to the floor, cuffed, then placed in the back of a police van. A short while later, PC Mark Knight's colleagues apologised for what had happened and released him. The driver was never accused of, arrested or charged with any offence. PC Mark Knights, on the other hand, was accused of committing a violent and unprovoked assault. The driver complained to the Professional Standards Department of Derbyshire Police. They did nothing, so the driver found me instead. He asked what could be done. It was clear to me that simply suing Derbyshire Constabulary would not be enough. This was the first time I'd come across an incident that would be more suitable for the criminal courts. So on the basis that the driver had 3 independent witnesses willing to corroborate his account, I agreed to pursue a private prosecution against PC Mark Knights. So the first thing I did was draft an application for prosecution and send it to Derbyshire Magistrates Court. I set the charges at common assault under Section 39 of the Criminal Justice Act and corrupt or other improper exercise of police powers and privileges under Section 26 of the Criminal Justice and Courts Act. The latter being an indictable offence tried in Crown Court with a maximum sentence of 14 years in jail. I then waited for the court to process the application. When Derbyshire Police got wind of the prosecution, they finally made the effort to contact the victim after 2 weeks. They made sympathetic noises and told him a full investigation would be undertaken. Who did the police invite to investigate the matter? None other than an incompetent police civilian, Richard Layton. From the outset, it was clear that Layton was conducting an entirely exculpatory and defective investigation as a means to ensure Mark Knights was never charged. To make matters worse, it turned out that PC Mark Knight's wife also worked for Derbyshire Constabulary in the Professional Standards Department, the department tasked with handling the complaint, a fact that was never disclosed to the victim as he had to find it out for himself. Due to these obvious conflicts of interests and the severity of the allegations, Derbyshire Police are statutorily bound to refer the investigation to the IOPC. Unsurprisingly, they never bothered, so I referred it to the IOPC on their behalf. The IOPC ignored my communication and failed to intervene. So I contacted the Derbyshire Police and Crime Commissioner, Hardy Dinsder, who, as of recent changes in police complaints process, has authority to take control of certain complaints. I invited him to do so. He had absolutely no idea what I was talking about, didn't know such legislation existed, and responded with patronising cut-and-paste responses that could have been authored by a 5-year-old. I also contacted the MP of the district the event had occurred in, Nigel Mills, to ask him, among other things, if the offending officer had been placed on restrictive duties. Nigel Mills never bothered to respond. In fact, every institution whose job it was to protect us from potentially dangerous police officers expressed not the least concern in what was happening. The police conducting a defective investigation against one of their own is standard evasion tactics and came as no surprise. If a police officer commits an unprovoked assault or unlawful arrest against a member of the public who then complains, the police will always close ranks and do whatever they can to save their colleagues. It's in their blood. The Blue Code of Silence, it's called. The protection of the police always comes before the protection of the public, and this was no exception. Richard Layton's aim, as with all police investigators, was to stretch out the investigation as long as possible so that it would exceed the 6-month time limit for common assault. That way the investigator can blame the courts and the CPS. Unfortunately for Layton, he couldn't pull that particular rabbit out of the hat because my application for summons had preempted him. On the 10th of February, he had to come to court along with PC Mark Knight's and Knight's solicitor and PC Mark Knight's wife. I came along with the victim, 2 witnesses and a journalist from the Derby Telegraph. Now here's the thing. If you were to headbutt a police officer, I could guarantee you 2 things would happen. 1, you'd be arrested and thrown into a cell within minutes. 2, you'd be up before the magistrates the following day and potentially placed on remand until the trial date. The police, as criminals, are excluded from that process entirely, and they are instead gifted a team of public servants whose job it is to ensure that prosecution never goes ahead. The CPS are part of that team, as they have been complicit in ensuring that PC Knights is not prosecuted and that public safety takes second place to saving a police officer's arse. When the police charge someone, it's always taken at face value by the courts that the prosecution has merit. This is how they're able to drag people through the courts again and again on malicious public order charges. A private prosecution is treated very differently. Rather than issue the summons, the judge first conducts what can only be described as a Newton hearing, a mini trial as it were, to determine whether or not to issue a summons. Now, I was never notified that such a hearing would take place, but I was more than prepared for it, having read the entirety of the criminal procedure rules. But what I was not prepared for was the unfairness of it all, such as the victim being placed on oath and questioned determinedly, while the police investigator was excused from oath and given the benefit of the doubt on everything he said. Also, when the victim pointed out to the judge that the officer's wife worked in the professional standards of Derbyshire Police, he was stopped from speaking on the basis that he was making unfounded and serious allegations. This, despite the fact that she was sat at the back of the courtroom and the statement was entirely true. I informed the judge that the lead investigator had conducted a deliberately defective investigation and he'd failed to notify the IOPC, despite his obligations to do so. I also had to repeatedly remind the judge that I had a right under Section 6 of the Prosecution of Offences Act to bring a private prosecution and that nothing within that gave the CPS the right to the first crack of the whip. Despite this, the matter was adjourned until the 2nd of April, allegedly so that Layton could conclude his already well sabotaged investigation. An investigation whereby he had deliberately excluded the body-worn video captured by one of the officers of the incident, and he'd refused to show it to the victim. He'd also refused to contact the 3 independent witnesses that the victim had gathered the details of at the scene. Layton gathered as little proof as he could, so that he could then submit an insubstantial file to the CPS and then blame them when they failed to prosecute. The CPS are equally as complicit. They know that police civilian staff should not be helming a criminal investigation against a potentially violent police officer, but they too are willing to look the other way. They regard the police as brothers in arms, a united front of stoking fear into the hearts and minds of the public that any divergence from the will of the state will not be tolerated. The CPS don't want to prosecute a police officer any more than the police themselves do, and they will accept the police's deliberately sabotaged investigation without question. That is precisely what happened because at the end of March, Richard Layton informed the victim that the CPS would not be bringing any prosecution. PC Mark Knights was, therefore, off the hook. Well, not quite, because now the ball had returned to my court. And the day before the second hearing, I wrote to the court and informed them that I would not be in attendance. There was no need, especially in the middle of an epidemic. In any event, the judge had admitted at the first hearing that a prima facie case had been made that the criminal summons should be issued, but that the police investigators should be given the opportunity to have the first crack at prosecution. Now that had passed, there was no reason that a summons shouldn't be issued, and my private prosecution against PC Mark Knight should be allowed to go ahead. Fortunately, the court agreed, and as a result, a summons was issued and a pre-trial date set. So, now I can proceed as intended and prosecute this officer in criminal court for the serious allegations made against him. Now, I'm not under any illusions about the difficulty ahead. The CPS will probably take over the case at the first opportunity they get, simply so that they can bury it. Certainly in cases where nobody will know it ever happened. The CPS should be putting public safety first above their allegiance to the police. But I've got little faith in the CPS, especially as recently, just like the police, they've used the coronavirus as yet another reason to stoke fear and control into the public, despite it being a misfortune to all of us. I'm up against multiple agencies, all of whom are determined to sweep this incident under the carpet, alongside the mountain of others they've swept away over the years. I'm bearing all the costs myself, and my entire prosecution team consists solely of myself and the victim. I'm extremely wary of using this channel as a means to obtain crowdfunding, but this is one of those rare cases where I feel it might be excused. So I'd ask in all sincerity, if you believe this prosecution to be as necessary and vital as I do, then I'd appreciate any donation you'd be willing to make to assist it. I shouldn't act surprised that not a single agency I've turned to has expressed the least interest or concern in this matter. It's obvious they serve the interests of the state status quo and not the interests of the public. If you want to get something done properly in this country, then do it yourself, including bringing private prosecutions against those who think themselves to be above the law. The police are not exempt from prosecution, especially for violent assaults against members of the public. So please help me send that message clear and loud to every police officer and police civilian staff in Britain. You are no longer guaranteed immunity from prosecution. If the state won't protect us from the criminality of the police, then it falls upon the public to do it for them.